Hurnam against PV Veerabudren.
Yes, Ms. Mockford.
My Lords, good morning. I appear for the appellant in this matter, Mr. Hurnam, along with my learned friend, Miss Connolly. My learned friend, Mr. MacLeod, appears for the respondent. The board will have seen from the parties' written cases that the issue in this appeal concerns the extent of judicial immunity for magistrates in Mauritius. And the appellant contends that the courts below erred in concluding that magistrates in Mauritius have an absolute and unqualified immunity from civil suit. And the overarching point that the appellant makes is that that conclusion cannot be reconciled with and fails to give proper weight to the Public Officers Protection Act 1957. There are three limbs to the appellant's argument which map onto the bases on which the courts below concluded that an unqualified immunity does exist for magistrates. First, the English common law and the 1957 Act itself, which we address together because we say that the common law informs the approach that the court should take to the statute. Secondly, the Mauritian Constitution. And third, the Mauritian Code of Civil Procedure. Our written case dealt with matters in that order, and if it suits the board, I propose to do so orally as well.
Yes, of course.
But first, I do want to make two preliminary points. First of all, I need to address paragraphs 6 to 9 of my learned friend's written case, which are at pages 42 to 43 of the key documents bundle. Those paragraphs make various allegations about the conduct of my client in a series of cases to which he has been a party before the Mauritian courts and indeed before the board previously. The appellant is described there as a serial litigant, and my learned friend also makes reference to a previous conviction that the appellant has. My client has asked me to make very clear to the board at the outset of this hearing that he does not agree with those paragraphs. The description of himself as a serial litigator is not one that he would accept or recognise, and nor, I am instructed, is the account given of my client's conviction and the challenges he has mounted to it and continues to mount to it, full or complete. His perspective, the appellant's perspective, is that at all times, including in this case, he has acted to enforce and vindicate rights which the Constitution and the legal system of Mauritius give to him.
Well, it's all irrelevant anyway, those.
I was going to say, in any event,
irrelevant prejudice.
They are irrelevant. They're wholly irrelevant to the appeal before the board, which relates to a narrow but important issue of Mauritian law and is obviously of wider application beyond the parties to this appeal, the facts of the case.
Yes.
Second, I want to say something about the cause of action on which my client relies and the issue which therefore arises for determination by the board. And I address this at the outset because at various points in his written case, my learned friend seems to suggest that the appellant's cause of action arises under the 1957 Act itself and or under common law principles derived from the English law. That is incorrect. As is made plain in our written case at paragraph 20 and also 66, little Roman numeral 4, it is Article 1382 of the Civil Code that supplies the cause of action in this case, not the common law. And importantly, there has been no suggestion made at any point of these proceedings that Article 1382 of the Code could not supply a cause of action that would cover the facts as alleged by my client. That was not the basis on which the matter was determined against the appellant by the courts below, and my learned friend does not suggest that in his written case. On the contrary, he quite rightly accepts at paragraph 13 that although the underlying factual circumstances are disputed, this preliminary issue, this appeal, has to be conducted on the basis that the appellant can make out his claim as pleaded, i.e. a claim under Article 1382 of the Civil Code. And what that means in my submission is that this preliminary issue and the appeal proceed on the basis that there is a valid cause of action. And the question for the board is whether the respondent has a defence to that action arising out of judicial immunity. So with that framing in mind, I'm going to come to address my first substantive topic, which is the English common law and the 1957 Act. And my submissions on this topic are going to be in three parts, my lords. I'm going to start by briefly looking at the judgment under appeal to see the approach that the Supreme Court took to this issue. I then want to make my submissions as to why that is wrong by reference to the case law and the terms of the Act. And then I'm thirdly going to come on to address what my learned friend has to say on this issue in his written case and respond to that. So starting with the Supreme Court's judgment, if I could ask your lordships please to turn it up. It's at Key Documents Bundle, page 71. This is about 5 pages into the judgment. Before this, the court has been dealing with background and also the constitutional issue, which I'll come back to. But its discussion of the common law position starts at the bottom of page 71, where reference is made to Syros and Moore. And you'll see there's a quote from Syros, which runs over to the top of the page, where Lord Denning said that ever since the year 1613, if not before, it has been accepted in our law that no action is maintained against a judge for anything said or done by him in the exercise of a jurisdiction which belongs to him. The words which he speaks are protected by an absolute privilege. The orders he gives and the sentences which he imposes cannot be made the subject of civil proceedings against him. And over the page, at the top of page 72, the quote goes on, you see the 2 underlined passages that the court was placing emphasis on, the court below, I should say. First, that no matter that the judge was under some gross error or ignorance, or was actuated by envy, hatred, or malice, and uncharitableness, he's not liable to an action. And secondly, in the middle of the paragraph, the words apply not only to judges of the superior courts, but to judges of all ranks, high or low. And over the next page or so, the court refers to 2 other Mauritian authorities. You can see at a glance from the bold text that in both of those judgments, Syros was referred to and was the basis for the Mauritian court's conclusion. So you see that from the 2003 Hurnam case, Syros and Moore quoted 2 lines down, and likewise the Hurnam and Mungley-Goulbel case, and Syros and Moore is quoted 2 lines down on page 73. In other words, the point I'm driving at is that Lord Denning's judgment in Syros is the bedrock of the Mauritian jurisprudence on this issue, and has led to the conclusion that what exists is an absolute and unqualified immunity from suit for both judges of the Supreme Court in Mauritius, which is the only superior court with unlimited jurisdiction under the Constitution, and magistrates sitting in the lower courts in respect of words spoken or acts done within jurisdiction. And for completeness, I should say that the Supreme Court then referred to 2 other sources. At the bottom of page 73, we see reference being made to Haggard and Pellissier Frere, which was a previous decision of the Privy Council from 1891. And then over the page, at the bottom of page 74, reference is made to Halsbury's Laws. It's an old edition, 1973, which is referred to, which is a year after Syros was decided, and some time before the House of Lords decision in Re McC, which I'm going to come to later. And so that is the analysis of the Supreme Court's, that's the Supreme Court's analysis of the common law position, that it confers an absolute and unqualified immunity for acts or words done in a judicial capacity or when exercising judicial functions.
Can you assist us? The common law enters Mauritian law how exactly, do you say?
I say it enters Mauritian law because the principles of the common law are relevant under the unified system the Mauritian law has, which incorporates both French law and English law. But I say, obviously, it's a principle of the common law, a trite principle, that it cedes to statute. And we need to consider also the acts of the Mauritian Parliament, to which reference was not made at all by the Intermediate Court in the first instance judgment, and only brief reference by the Supreme Court in its judgment under appeal. But I accept that the common law does enter the Mauritian legal system. We addressed that in our written case as well.
On what basis does it enter Mauritian law? Is it because it's a constitutional principle and common law constitutional rules apply to a ceded territory?
Yes, and it's also because, broadly speaking, Mauritian adopts a Westminster system of constitutional law, and its acts have been held previously to be therefore interpreted in accordance with common law principles. So I accept that the 1957 Act, for example, has to be interpreted in accordance with common law principles. I don't think there's much dispute between me and the respondent about that. I accept that the Napoleonic principles, which are in the Civil Code and the Procedural Code, were then incorporated into Mauritian law. But after the British took over Mauritius, the common law also came in, and in particular through different aspects of the law. So we see it having particular importance in company law, for example.
Well, my question, I think my Lord's question were directed to, one can talk in generalities about the common law comes in as well, but I just wondered whether you had any submission to make about how that happened precisely, because the usual rule was that where the Crown took over what's sometimes called ceded territory or already settled territory, it would take over the law of that territory, subject to a power to change it. Which means that there's a little bit of a question mark as to how the common law, or this principle of the common law, does enter Mauritian law. Did you want to say anything about that?
Well, my submission is that the common law is relevant because the Mauritian Parliament has adopted legislation which apes the English legislation. So the 1957 Act in particular has clear pedigree in English law, and I'll show you some of the English legislation that's relevant to that. And I therefore say in its interpretation, what the common law has to say about judicial immunity and what the common law has to say about the interpretation of the 1957 Act is highly relevant.
But those are two different things, aren't they? It's one thing to say it's relevant to the interpretation of the Act. It's another to say you've got a common law principle there, which the Act comes on top of.
Yes, I accept that. I think in this case, the two lead you to the same conclusion because the Act is, in my submission, regulating judicial immunity for magistrates in Mauritius, and that's exactly what the common law has also been interested in doing, and therefore the two bring you to the same terminus in my submission.
I mean, is there a background in the pre-existing French law in terms of controlling actions against judges?
There is. Those are the provisions of the procedural civil code, Articles 505 to 513, which set out the pre-partie procedure. And I'm going to come on to the question of how the 1957 Act interacts with that. But there absolutely are principles that derive from both the French law and from English law. That's my submission.
All right. All right. Thank you.
So I've shown you how the Supreme Court approached the common law position and the conclusion it reached on the basis of its consideration of Syros and Moore. And in my submission, the error that the Supreme Court fell into in that regard is that it proceeds as though Syros and Moore was the last thing the common law had to say on the issue of judicial immunity for magistrates, when it was not. In my submission, it's the departure point rather than the terminus for an analysis of the case law. And if we could start by turning to Syros, it's in the hearing bundle at page 1197.
Yes.
Let's have that. The facts are set out in the head note, and we can take them quite quickly on page 1197. Mr. Syros, as it records there in the first line, was an alien, who was a Turkish citizen, I believe, who had overstayed. He was fined and recommended for deportation for breach of the aliens order, and the magistrate directed that he should not be detained pending decision of the Home Secretary on the recommendation. Mr. Syros appealed, and that appeal came before the Crown Court. And at the hearing, counsel for the prosecution submitted that the court had no jurisdiction to hear an appeal against a recommendation for deportation. The court accepted that submission, and then you see the relevant sequence of events set out between paragraphs E and F on page 1197. The judge said the appeal's dismissed. Mr. Syros got up and left the court. When the judge saw him going out, he called out, "Stop him." Police officers complying with that direction followed and told him he was being taken into custody. And the judge then ordered his detention. An application for habeas corpus made on the next day on Mr. Syros's behalf, and the divisional court's conclusion is at paragraph G. They said, well, the judge had been functus before he began to consider whether or not Mr. Syros should be detained. And then at paragraph H, you see recorded the fact that Mr. Syros then issued a claim against the judge and the police officers for assault and false imprisonment. And that was the claim that was before the court on this occasion. Lord Jennings' judgment starts by considering what had happened below and the way in which the hearing had proceeded, and that detail isn't particularly pertinent for us. But in essence, he holds that the Crown Court was wrong to find that it lacked jurisdiction to hear the appeal against the original magistrate's decision. It had jurisdiction, and on the appeal, it could have made any order that the magistrate could have made. So he summarises the position at page 1210, 1210, at paragraph F, where he says, well, we have this strange result. The judge held by mistake that he had no jurisdiction to hear the appeal, but he did in truth have jurisdiction. And if he had exercised it, he could have affirmed the recommendation for deportation. He could have reversed the direction that the man be not detained, and in lieu, he could have ordered him to be detained in custody pending the Home Secretary's decision. But the judge did not do so, he simply dismissed the appeal. And in the next two paragraphs, we see consideration given to the Divisional Court's reasons for releasing Mr. Syros. In short, that the judge was functus when he detained Mr. Syros because he had said appeal dismissed. And Lord Denning says that conclusion was right, but not the reasoning. He wasn't functus because he had statutory power to vary his order. You see that at paragraph H at the bottom of page 12110. But the point is he didn't do so. And so he sums up at 1211 at paragraph C. He says the truth was that the judge had simply dismissed the appeal. That left the magistrate's order intact, including the direction that he was not to be detained. In these circumstances, the Divisional Court were quite right to issue a writ of habeas corpus for the release of Mr. Syros. And then Lord Denning gets to the critical issue for our purposes, that of judicial immunity. And over the next 2 pages, you can see that he deals with that in 2 sections. He starts with heading number 1 at paragraph D on page 1211, acts within jurisdiction. And then over the page at 1212, acts without jurisdiction, he deals with separately. And at page 1211, E to H, we see the passage cited in the Supreme Court's judgment below, which I showed you earlier, where it said that no action is maintainable against a judge for anything said or done by him in the exercise of a jurisdiction which belongs to him. And the paragraph concludes at H, those words apply not only to judges of the superior courts, but to judges of all ranks, high or low. And you see that at the top of page 1212, the next page, Lord Denning cites Lord Esher in Anderson and Gorry as authority for that proposition, which I just note because it's a case that my learned friend relies upon. And I would accept that if one looks at that passage, the position seems quite unequivocal. The suggestion is that any judge doing an act within jurisdiction has absolute immunity. But actually, even Lord Denning goes on to acknowledge that the position is not that clear-cut for some classes of judges, including magistrates. And we see that in the next section, which is headed Acts Without Jurisdiction. So he says at paragraph B, a distinction must be drawn for acts without jurisdiction between the inferior courts and the superior courts of record.
Sorry, let us see.
Oh, B, just by B.
Right, thank you.
And then at C, so at B he says that there's a distinction that exists. At C he summarises the position for inferior courts. And he says, well, so far as they are concerned, it was established for centuries that a judge of an inferior court was only immune from liability when he was exercising, albeit wrongly, a jurisdiction which belonged to him. It did not exist when he went outside jurisdiction. And then notwithstanding the heading given to this section, which is acts without jurisdiction, at H, at the bottom of the page, he actually returns to the topic of acts within jurisdiction. And there he says the principle, the one he set out above, which is that judges of inferior courts do not have jurisdiction when they go outside their jurisdiction. Sorry, do not have immunity when they go outside their jurisdiction. It's been repeated 1,000 times. It was only applied, so far as I can discover it, to the inferior courts. The judges of the superior courts were very strict against the courts below them and were particularly hard on justices of the peace. The reports abound with cases where they were held liable in damages. And then he goes on to say, not only were the justices of the peace, I'm at the very bottom of the page, held liable for acts done outside their jurisdiction, they were also liable, at the top of page 1213 he goes on, for acts done within their jurisdiction, if done maliciously and without reasonable and probable cause. Section 1 of the Justices Protection Act 1848 was passed on this footing. So actually that's a qualification to what he said earlier in the judgment, that for acts within jurisdiction the position is settled and clear for all judges. It was not so for justices of the peace, because historically they could be liable even for within jurisdiction acts if done with malice and without reasonable and probable cause. At C, he contrasts that with the position of superior court judges, where he says even though a judge of a superior court has gone outside his jurisdiction, nevertheless he's not liable so long as he is acting judicially. And he disagrees with this distinction, Lord Denning, between judges of the inferior and superior courts. And we see that disagreement being expressed at page 1215.
So can you help us? When Lord Denning refers at page 1213 at A to the protection given by Section 1 of the Justices Protection Act, does he explain why it was passed? Was it passed because courts were imposing liabilities, forgetting the earlier principle that any judge acting within jurisdiction had full immunity, and therefore it was passed sort of out in abundance of caution? Or is there some explanation by Lord Denning to reconcile the two parts of his judgment?
Lord Denning doesn't explain that. We'll get into it.
Okay.
Just note that the 1848 Act that he refers to wasn't the first act to deal with justices of the peace. The first act, as far as I'm aware, and we haven't gone back further than this, but was 1803, so there had been an act in place before that. It's something that is picked up to a degree in the House of Lords decision in Imrie McC, so perhaps we can come back to that
Yes,
in
certainly.
due course.
Thank you.
Lord Denning, over the page, as I was saying, at 1215, expresses his disagreement with the distinction that he says has existed historically between judges of inferior and in superior courts. You can see at B, he says, in this new age, I would take my stand on this as a matter of principle. The judges of superior courts have no greater claim to immunity than the judges of lower courts. Every judge of the court of this land, from the highest to the lowest, should be protected to the same degree and liable to the same degree. And at F, for completeness, he says this principle should cover the justices of the peace also. Over the page then at 1216, just to wrap up on Lord Denning's judgment.
But as a matter of principles, what do you say about that?
I say there may be good reasons for saying that justices of the peace, for saying that magistrates should have the same immunity as judges of superior courts. And certainly the position has moved on in this jurisdiction, although it is still the case, even under the Courts Act 2003 today, that they don't have precisely the same immunity because they can be liable for without jurisdiction acts done in bad faith. It's a point I'm going to come to, my Lord, but certainly I say that one can't assume that the policy considerations are the same in Mauritius. And that in light of the 1957 Act, the question of whether that protection should be extended as a matter of principle, as a matter of policy, to justices of the peace, to magistrates, in the same way as it extends to Supreme Court judges in Mauritius, is a question for the Mauritian Parliament to determine. And I am going to come back to that, if I may. So yes, just to wrap up on Lord Denning's judgment at C on the next page, 1216, we see him expressing his conclusion on the case. Though the judge was mistaken, yet he acted judicially, and for that reason, no action will lie against him. And so we see where Lord Denning draws the dividing line for judicial immunity. He says the only question is whether the judge was acting judicially or in a judicial capacity. That's all that matters. And the other judgments in this case, I don't think we need to go through them in as much detail, but they were given by Lord Justice Buckley and Lord Justice Ormerod. And Lord Justice Ormerod, in summary, takes effectively the same view as Lord Denning. He made the point that judges of inferior courts and justices of the peace have always been treated differently. That, for your note, is at page 1226F. And then he goes on to express his agreement with Lord Denning that that double standard, as he calls it, cannot stand, and that the old rule should be modified by giving judges of inferior courts, including magistrates, he makes express enhanced protection. That's at 1228G. Lord Justice Buckley reached the same ultimate conclusion as Lord Denning and Lord Justice Ormerod, i.e. that the judge below had immunity, but on a different basis. His view was that the judge in question had jurisdiction when he ordered Mr. Syros be detained, which we saw as what Lord Denning was also saying. He may have followed an irregular course in doing so, but he had the power to do it, and so he was acting within jurisdiction, and this was a conventional within jurisdiction act for which judicial immunity would apply. And that reasoning, for your note again, is at page 122 from paragraph E over to paragraph E on the next page, 1223. So standing back, there are two propositions that I draw from Syros. First, a recognition that historically, at least, there has been a distinction between the judicial immunity afforded to judges of superior and inferior courts, and in particular to magistrates or justices of the peace. Both Lord Denning and Lord Justice Ormerod recognise that as a matter of historical fact, albeit they both say it should no longer be so.
Well, just on that, isn't that them expressing a view about the way in which the common law can develop?
Yes. Yes, I accept that.
And why couldn't the common law develop in Mauritius in a similar way?
Because of the curtailment that's imposed by the 1957 Act. That's my response to that, which I'm going to come to.
Yes.
The difference, the second proposition I draw is that difference included, per Lord Denning, that justices of the peace were held liable, not only for acts done outside their jurisdiction, but also for acts done within their jurisdiction, if done maliciously and without reasonable and probable cause. Now, if the law had stopped there, then I accept the court below would have been right to say that the common law position is effectively to look at whether the act being done is being done in the exercise of judicial functions and nothing more. That's what I'm going to call the Syros and Moore approach. It's the same as the approach taken in the previous Anderson and Gorey case. But the law didn't stop there. Instead, on the contrary, Lord Denning and Syros was overruled by the House of Lords some 10 years later in Re McSee. And if we could go to that, let's please at page 725 of the hearing bundle. My lords have that.
Yes.
Again, the facts can be taken from the head note. A 14-year-old juvenile had pleaded guilty to charges relating to a motor vehicle, was ordered to attend an attendance centre. He failed to do so, and a time later he appeared before the same bench of justices upon charges of failing to attend. He wasn't legally represented, hadn't applied for legal aid, and wasn't informed of his right to do so. And the justices ordered that he should be sent to a training school, and he was detained pursuant to that order. The order was subsequently quashed, we see it at the top of page 726, by the Divisional Court on an application for judicial review, because the relevant Northern Irish legislation, the Treatment of Offenders Order 1976, required that he should have been informed of his right to legal aid, and that hadn't been done before his detention. So it was quashed, and then he subsequently commenced a civil action against the 3 justices constituting the court, claiming damages for false imprisonment, you see this at paragraph B, trespass by the person, and breach of statutory duty. The claim was dismissed at first instance, but allowed on appeal, and a further appeal to the House of Lords that we're looking at was dismissed. Lord Bridge delivers the leading speech, and I want to go through it in some detail. If we can go to page 732, please. And the reason I say it repays going through in some detail is because it considers the statutory scheme in both Northern Ireland and England, including historically, and goes through it over time. At paragraph C on page 732, Lord Bridge sets out the issue for determination by the board. There was a preliminary issue of law on the question in substance whether on the facts pleaded any action would lie against the appellants. And this, he says, in turn depends on whether the appellants, i.e. the magistrates, in making the training school order acted without jurisdiction or in excess of jurisdiction within the meaning of those words in section 15 of the Magistrates' Courts Northern Ireland Act 1964. There are a lot of acts with similar names here, so I'm going to try and refer to them by date. This is the 1964 Act. And you see the terms of that section set out fully at paragraph G further down the page.
We don't have on this appeal any issue, do we, about whether the Act was within or outside jurisdiction?
We do not. It was a within jurisdiction Act. That's acceptable.
Therefore, nothing decided in McSee is directly in point.
That's true entirely, but it is, I say, the highest and latest consideration of the issue in broad terms.
No, I recognise that, but I'm just making sure I understand the parameters.
Absolutely right. My lord is completely right. So the section 15 is set out at G, and if I could ask your lordships to read that, please. And at H to A, Lord Bridge then sets out his first impression of that section, H of that page to the top of the next page. which he says will be confirmed by consideration of the relevant Irish legislative history, the analogous legislation in England and Wales, and the decided cases. But his first impression is that if someone suffers an actionable wrong pursuant to an order made by justices acting as such, it's a complete defence that they acted within their jurisdiction, but no defence if they acted without jurisdiction or in excess of jurisdiction. And then at page 734, A to C, he identifies the question for the task for the court as being to identify on which side of the line the instant case falls. And he says, well, the answer to that question isn't seriously in doubt, but he goes on to note that this is the first ever case to come before the House of Lords, related specifically to the civil liability of justices arising from the performance or purported performance of their duties as such. And it's obviously desirable, he says, so far as it may be possible, that the House, beyond deciding the appeal on its particular facts, should make some attempt, however daunting the prospect may seem, to discover and pronounce any principles of general application in relation to justice's civil liability, and if essentially the same principles apply, both in Northern Ireland on the one hand, and in England and Wales on the other, to say so. I emphasise that because it explains the weight I place on this case to my Lord's question, and also in answer to my learned friend's case at paragraph 36, where he expresses some surprise about the weight we place on Imrie McSee. In my submission, it's both the highest and most recent consideration of the liability and immunity of magistrates, and it traverses both the law of Northern Ireland and England and Wales, and seeks to expound principles common to both of them. And you see that principle starting in the following paragraph, which refers to the Justices Protection Act 1848, so the English 1848 Act, and the Justices Protection Act Ireland 1849, so the Irish 1849 Act. And then he quotes sections 1 and 2 of the Irish 1849 Act, which he says are not quite verbatim, but have identical effect to the first two sections of the English 1848 Act. So if I could again ask your lordships to read sections 1 and section 2 up to there's a colon in the middle of the paragraph.
Do you think there's some reason why he's chosen the Irish Act in preference to the English Act?
Well, he was dealing with an Irish case. I think
right.
that's probably all that
Yes.
He says they're the same. So.
one can read into them. Yep. My lords
Yes.
have that. Just going on, I'm going to come back to make some points about the Acts. At 735C to D, he makes the point that those sections remained in force until repeal by the 1964 Northern Irish Act, section 15 of which we've already looked at, he's already set out. And then at 736A, over the page, he makes the point that the equivalent sections in the English 1848 Act remained in force until they were repealed by the Justices of the Peace Act 1979. And then he sets out the relevant parts of the 1979 Act. And again, could I ask your lordships to read section 44 of the 1979 Act and section 45.2, please. And I'll make some points about all this legislation.
Two, did you say?
Yes, in the middle, around paragraph F.
Yes, thank you.
So there are 2 points I'd emphasise about these sections just while we've read them. First, Section 44 relates to acts done by a justice in the execution of his duty and within jurisdiction, while Section 45 relates to acts done in a matter in respect of which, by law, he does not have jurisdiction or in which he has exceeded his jurisdiction. So there's a clear demarcation being drawn in these two sections between the two types of acts, which are separately addressed. And you saw that as well in the preceding 1849 Irish Act. And for completeness, it's true also in the English 1848 Act. And second, I say it's worth contrasting the language of Section 44 with that of Section 45 too, because it's in, Lawbridge picks it up later on, it's important to what he goes on to say. So Section 44 starts with the words, if apart from this section any action lies, which makes completely express that this section itself is not founding or giving rise to a cause of action. But it goes on to be prescriptive about the form that any such action should take if it does lie, which is that it shall be as for a tort in the nature of an action on the case. And you contrast that with Section 45(2), which provides that any person injured by an act to which that section applies, i.e. without jurisdiction act, may maintain an action against the justice and without doing certain things, i.e. making an allegation of malice or a lack of reasonable and probable cause. So that is the evolution of the legislation in both Northern Ireland and England. And then we get to Lawbridge's analysis of it.
I'm sorry, I wasn't sure what point you were making on Section 45. Are you saying that this founds a cause of action?
What Lawbridge says, and I adopt his analysis of what that section does, is that it gives statutory force to a cause of action of that nature. And what I understand him to mean by that, and this is certainly my submission as to how this works, is that it removes the ability of a defendant magistrate to rely upon judicial immunity to defeat that cause of action. And therefore, while I don't think Lawbridge is going as far as saying this founds the cause of action, and the cause of action in this case, of course, was unlawful detention, trespass against the person, those aren't founded by this section.
No.
What he is saying is it gives statutory force, that's his words, statutory blessing, if you like, to cases of that, to claims of that nature, by removing the ability for the defendant to rely on judicial immunity. So, of course, you have to meet the other requirements of that cause of action, whatever it is. But a defendant magistrate can't say, in light of 45(2), well, I have judicial immunity, so this claim never gets off the ground. That's how I say Section 45(2) works, and I think that's Lawbridge's analysis of it as well.
Thank you.
So we get to his analysis at page 737D, where it starts, paragraph D, where he says the language of Section 15 of the Northern Irish Act of 1964, which we looked at previously, is back on page 732 if you want to go back to it, plainly abolishes the old common law action on the case as for a tort against a justice in respect of anything done by him maliciously and without reasonable and probable cause within his jurisdiction. And at E, he makes the point that it wasn't open to the draftsman of the English 1979 Act to do the same because it was a consolidation act. But he says he used the opening words, if apart from this section any action lies, to manifest his doubt as to the survival of the old common law cause of action. And then he goes on to make the point at paragraph F that anything he says on this topic is going to be obiter because there's no question of malice, either within or without jurisdiction, which arises in the appeal. But he thinks it's right to comment on it nonetheless. And we see what he says about it over the following page or so. He cites Anderson and Gorey at the bottom of the page, paragraph H, and says at the top of the next page that the principle underlying the rule is clear. The rule expressed in Anderson and Gorey, i.e. that there can be no action against a judge of a court of record for doing something within his jurisdiction, but doing it maliciously and contrary to good faith. And then at B to D of page 738, he says that if the old common law rule was different in relation to justices of the peace, he suspects that that had its origins in society's view of the justice reflected in Shakespeare's play as an ignorant buffoon. And he goes on to describe that as a ludicrous anachronism. And at the bottom of that paragraph, close to indentation E, just above it, you see him saying, it follows that, in my opinion, the old common law action on the cases for a tort against justices acting within their jurisdiction, maliciously and without reasonable and probable cause, no longer lies. But then he goes on to consider the position in respect of acts outside jurisdiction in the following paragraph, where he says the position is entirely different.
Just pausing there, that obiter passage is agreed to by Lord Elwyn-Jones and Lord Templeman.
Yes, that's right. Lord Elwyn-Jones agrees fully with Lord Bridge. Lord Templeman also agrees. Lord Keith and Lord Brendan agrees with the speech save in respect to that point, where they say they would rather reserve their position because it's obiter. So I just want to consider what he says about outside jurisdiction acts, and then I'll make my submissions about what I take away from his analysis. So at 738E, he says, by contrast, the position is different in respect of acts outside jurisdiction. And if I could ask your lordships to read from E to the very top of the next page, paragraph A on page 739. So in my submission, there are 4 points that I take away from this analysis. First, that there is a distinction between the immunity of magistrates and other judges. The Anderson and Gorey, or the Syros and Moore formulation, that no action lies for acts done or words spoken by a judge in the exercise of his judicial office, isn't accurate for magistrates. Because for magistrates, you also have to ask, is this a case within or out with jurisdiction? Second, in Lord Bridges' view, as a matter of English common law, there is no longer any cause of action that lies against a magistrate for within jurisdiction acts done maliciously. And made clear in response to my Lord Hamlin's question that his comments on that point were obiter, and some of the other judges prefer to leave the question open. But the point was, in any event, in England, 5 years later or so, overtaken by statute, because the Courts and Legal Services Act 1990 effectively took the same approach as Section 15 of the 1964 Northern Irish Act, in making it clear that no action would lie against a Justice of the Peace in the execution of his duty with respect to any matter within jurisdiction. And that remains the case today under Section 31 of the Courts Act 2003. But
I think Lord Bridge would say that's declaratory of the common law,
yes,
in his view.
yes. But I say that point about the cause of action isn't material to this case, because I said at the outset, the appellant does not look to the English common law to supply his cause of action. He derives that from Article 1382 of the Civil Code. So I say this discussion about the common law, that doesn't matter in terms of the cause of action. But third, where I say this does...
It amounts to a decision that there is immunity.
Well, that's what I was going to come to. So third, where there is a valid cause of action, what I take away from Lord Bridges' speech and the submission I urge upon the board is that when one is considering whether a magistrate will be able to avail themselves of the defence of judicial immunity, it's necessary to pay close attention to the governing statute. It's a trite observation to make that the common law sees to the statute. And that is the explanation for the fourth point I made, which is that on Lord Bridges' analysis...
I'm sorry, could you repeat the third point? I missed it.
My third point is that where there is a valid cause of action, but you're considering whether a magistrate will be able to avail themselves of judicial immunity as a defence to that cause of action, it's necessary to pay close attention to the statute that deals with that point. And that ties into my fourth point, because on Lord Bridges' analysis, while the viability...
I'm sorry, still dwelling on your third proposition. What's the significance of your third proposition? Sorry, I haven't followed that.
The significance of my third proposition is borne out by the way in which he approached the difference between Section 44 and 45.2, for example, of the English 1979 Act, I'm going to say it's very material in this case because the Mauritian statute, the 1957 Mauritian statute, in my view, is regulating judicial immunity, but in a different way to the way in which the Courts Act 2003 now does in England, or that Section 15 of the Northern Irish Act did under consideration in Imrie McSee. So I say, in other words, what he's getting rid of, the thing he's getting, obiter, it's all obiter, but the thing he's getting rid of, and we can accept that it's gone from the English common law, is a cause of action for a case on, as for a tort, action on the case as for a tort. That's what he gets rid of. That's what he says is gone for magistrates. But it doesn't affect, where the statute intervenes, the scope of judicial immunity that can be pleaded as a defence. And you see that, my fourth point was perhaps a 3B really, because you see it from his analysis of the difference between Section 1 of the 1848 Act, or Section 4 of the 1979 Act, and Section 2 of the English Act of 1848 and Section 45 of the 1979 Act. Because what he's saying in these paragraphs is that Section 1 of the 1848 Act left the common law to determine whether there was a cause of action for within jurisdiction acts. Whereas Section 2, or what is now, when he's considering it, Section 45(2) of the 1979 Act, gave statutory force to actions for acts of magistrates done without jurisdiction or in excess of jurisdiction.
But I think only because it was taken to be recognising and confirming what was the common law position.
Well, he says that, if we look at what he says, F to G...
On, sorry, which page?
on page 738.
Yes.
He says whether or not the language used was, as Hutton J, in my opinion, rightly held it was, declaratory of the common law, the words may maintain an action against such justice in the same form and in the same case as he might have done before the passing of this Act, gave statutory force, which survives in Section 15 of the 1964 Act and Section 45 of the 1979 Act, to the old common law rule that justices were civilly liable for actionable wrongs suffered by citizens pursuant to orders without jurisdiction. It follows that it's now a statutory rule, expressed in positive terms, in Section 45(2) of the Act of 1979, and he says he's already indicated his opinion that the negative form in which the rule is expressed in Section 15 of the Northern Irish 1964 Act has a similar positive effect.
Right.
So that is not, it's what we're not concerned with here, but he's saying that there's nothing the common law can do about the rule that magistrates may be liable for things outside their jurisdiction.
Because
the statute has enshrined that.
Exactly. So whether or not it was declaratory of the common law doesn't much matter. It's now in statute and it takes statutory form.
But conversely, for acts within jurisdiction, that is subject to the common law because neither the 1979 Act, 45(2), was it?
44.
44, nor Section 1 of the 1848 Act made a statutory rule. It just assumed a common law position.
Exactly.
It was a procedural provision only.
Yes.
And if the common law changes, then there's nothing for it to bite on.
That's exactly the dividing line that Lawbridge is drawing between those two sections.
And so the crucial thing will be as to whether our Section 6, when you're coming to that, is like Section 1 or whether it's different.
Precisely. That's exactly what I get from this.
Well, you would agree, would you, that it doesn't turn on the words that the draftsman put in at the beginning of Section 44, if apart from this section any action lies, because Lawbridge is not basing his analysis on that. He's saying that was all the draftsman could do, but he's accepting that position was already procedural under Section 1 of the earlier Act.
Yes, to that, I say that is a relevant feature of the 1979 Act, section of the introductory words to Section 44, but it's not the thing that determines that this section is making it completely express that the common law position is what trumps, but it's not the thing that determines that. And I'm going to show you that in my submission the position is different under Section 6 of the 1957 Act in Mauritius. But you're precisely right, my lord, about what I'm drawing from the facts of this case and from the analysis that Lord Bridge sets out. And I'm going to be turning to the Act, the Mauritian Act, very shortly.
So, I'm so sorry to interrupt, but that way of expressing it makes it sound as though we are concerned with the development of the common law, but I understood you previously to be drawing a distinction between the common law position and the position in Mauritius, which is governed by Article 1382 of the Procedural Code.
I think my answer to that is that the cause of action here is supplied by Article 1382 of the Civil Code.
Not the common law.
Not the common law. And I say the scope of the defence that a magistrate might have to that based on judicial immunity is also not really informed by the common law anymore because the position has been made clear by the 1957 Act. I say it's
well, I'm not sure. Are you making, is it one submission or two? It's taking up my lord's point, really. I mean, are you making another submission that, regardless of whether that you're right on the 1957 Act, if that's the right year, Lord Bridges' analysis doesn't apply because we're dealing with the code and not with the common law? Or are you accepting that the common law, although he talks about a case in tort, if there's a common law rule, it's a rule of immunity that applies whether you're dealing with tort strictly or code wrong?
I'm not accepting that the common law anymore regulates the scope of judicial immunity in Mauritius, because I say it's now, that field is now being occupied by the 1957 Act.
Right, but that way of putting it rather gives me the impression that you're not seeking actually to draw a distinction between Article 1382 of the Procedural Code and the common law. They're both forms of tort liability for these purposes, and your focus is on the scope of the immunity.
Yes, absolutely.
That's correct.
Absolutely.
So in effect, we can put out of our minds that the cause of action may be based in Article 1382 rather than the common law, because the two run together, and either they hit the buffer of a common law immunity or they don't.
Either they hit the buffer of immunity under the Act or they don't. That's the only qualification I would make to that summary.
All right, but when I put it that way, I was taking it as read that your case is they don't hit the common law buffer because of the statute.
Well, I say that they don't. I say that in the same way that Lord Bridge was saying that Section 45 of the 1979 Act may be declaratory of the common law, may not, but there is now a statutory rule. I say likewise in Mauritius, there's now a statutory rule that actions, that judicial immunity cannot be pleaded as a defence to actions falling within its scope.
But to just follow up my previous question, do I understand then that if you're wrong about the statutory rule, you don't have a second string to your bow, as it were, based on then a distinction between common law and civil code? You've just got one argument.
We've got the statute.
Based on the statute.
Yes, we've got the statute.
Yeah. Yes.
Yes.
Right.
And we say it's the statute that's giving blessing, if you like, to this type of action. I think it can get slightly confusing in the case because of the idea that you're giving blessing to the cause of action. It's not really that you're giving blessing to the cause of action, but you're giving blessing to claims of the nature that fall within the statute because a defence of judicial immunity can't be raised to them. That's how I say it works.
Right. Thank you.
Just to wrap up on Lord Bridges' speech, and then I will be turning to the Act, the 1957 Mauritian Act. At 7.4, there's a long passage after this where Lord Bridge discusses whether this was a...
Sorry, which page?
I'm going to 747.
747.
Yeah, I was just going to say that Lord Bridge discusses whether this was a inside or outside jurisdiction act in his case, but I don't think that's particularly relevant. But at 747, just to note that between F and G, Lord Bridge discusses again the decision in Syros and expressly says that Lord Denning's judgment in favour of abolishing the distinction between superior and inferior courts cannot possibly be supported in relation to justices. And he says that even for the narrower question of whether inferior courts have the same immunity as superior courts, such a distinction is so firmly rooted in the law that it would require legislation to change it. And I do place some emphasis on that to a question that in response to a question I was asked earlier about the policy considerations that apply here and how they pan out, which I'm going to come back to. But he ultimately says, well, the outcome in Syros could have been supported on the much narrower ground expressed in the judgment of Lord Justice Buckley, which in essence was that the irregularity of procedure did not deprive the judge of his jurisdiction. In other words, it was a within jurisdiction case. You see that at 7.4 through the page on 7.48. And so you get the conclusion on the facts before him at 7.49, paragraph F. The appellants and the magistrates acted without jurisdiction or in excess of it, and the appeal was dismissed, meaning that the claim against them for false imprisonment, amongst other things, breach of statutory duty, could be maintained. Obviously, it had to be made out at trial, but it could be maintained in the face of their status as magistrates. That takes us then to the Mauritian Act of 1957, which is in the hearing bundle at page 1587. Fairly short piece of legislation. The title of the Act is the Public Officers Protection Act. I just note in passing, it's an act for the protection of public officers. Section 1, 2 and 3 are not particularly relevant to us. Sections 4 and 5 on pages 1588 to 1589 are relevant because Section 4 imposes, per its heading, limitations of actions. And there are a range of limitations that it imposes. Under Section 4.1, there's a limitation period, for example, imposed of 2 years, which was then extended by 4.1a during COVID. 4.2a imposes a requirement as to pre-action conduct in the case of any civil suit. In particular, that 1 month's previous written notice of the action has to be given to the defendant. 2b is a stipulation that no evidence should be produced at the trial, except as specified in that notice. So it's constraining. You can't expand your case at trial beyond what was specified pre-action. Section 4.2c imposes a cost sanction if you fail to send the requisite notice. 4.3 is a quite unusual provision that effectively empowers the unilateral settlement of a dispute, as I read it. The defendant can make a payment into court, or if it's pre-action, make an offer, which if it's determined to be sufficient by the court, means that the case shall be dismissed. And then 4.4, if the defendant acted upon reasonable or probable cause, the plaintiff should not be entitled to more than nominal damages or any costs. And Section 5 makes further provision for nominal penalties in particular cases relating to seizures. And then we get to Section 6, which is the critical section for our purposes. So Section 6.1a applies Sections 4 and 5 to a civil or criminal action, suit or proceeding brought against a magistrate or a clerk or officer of any district or other court for any act done by him or for any omission in the execution of his office. And I pause there to observe that in the execution of his office is effectively the Anderson and Gorey or the Syros and Moore test that the Supreme Court in this case, in the judgment under appeal, has said triggers absolute immunity. You've done it in the execution of your judicial office, you get immunity. So if the Supreme Court is right, Sections 4 and 5 are being applied by Section 6.1a to a class of action that can never be brought. Then we get Section 6.1b, which says that subject to subsection 2, the plaintiff shall also expressly allege that the act was done or omission made maliciously and without reasonable and probable cause. Section 6.1c imposes another cost sanction if that isn't made out at trial. The defendant should be entitled to judgment with treble costs. And then Section 6.2 relates to actions outside of jurisdictions. So it defines the scope of the actions in 2a, 1 and 2. It says, well, in those cases where a magistrate, clerk or officer has exceeded his jurisdiction, any person injured by that act may maintain an action without averring and proving that it was done maliciously. I make 4 points about how this section operates. First, and at the risk of stating the obvious, It's definitely not doing what Section 15 of the Northern Irish Act that was being considered in Remix C did, nor what Section 31 of the Courts Act 2003 does in England. Those sections positively and expressly prohibit any claim for within jurisdiction acts of magistrates. The way that Lord Bridge put it was that they abolished that cause of action if it ever existed. Section 6 of the Mauritian Act definitely does not do that. Second, I say Section 6 is neutral as to the cause of action. This goes to my Lord Sales point, I think. If anything, I don't know if something can be more neutral, but I say it is more neutral than the English Acts of 1979 and 1848. Because Section 44 of the 1979 Act made clear, first of all, in its introductory words, as we were just looking at, that it wasn't itself providing a cause of action, but also, and in common with Section 1 of the 1848 Act, it went on to make clear that if an action was to be brought, it had to take a specific form. It had to be an action on the case as for a tort. And I say both of those things in the English Acts were directing the reader, the court, to the common law to look for the cause of action in dispute. Whereas, so they were leaving the common law to supply the cause of action, but they were being prescriptive about the form that that cause of action had to take. And it was a cause of action recognised and regulated by the, recognised or not recognised, but regulated by the common law. It's a common law cause of action. That is not the case here. There's no suggestion in Section 6 that any cause of action has to take the form of an action on the case as for a tort, for example. On the contrary, it uses wide words at Section 6(1)(a), in that it applies to a civil or criminal action, suit or proceeding. And I say that reflects the mixed legal system in Mauritius.
I'm sorry, you say that?
Reflects the mixed legal system in Mauritius. And the fact that, as in this case, one can derive a cause of action from the civil code, as well as, or alternatively, to the common law. It may be that you have a common law cause of action too. If the facts were different, you could be in the territory of false imprisonment, for example. That's not our case, but you could have a common law cause of action, or you could have a civil code cause of action. I say it's neutral as to that issue. But third, I say it's not neutral as to when judicial immunity may be prayed in aid by a magistrate as a defence to a valid claim. Rather, in my submission, what Section 6 is doing is regulating both the procedural aspects of claims against magistrates, that's 6(1)(a), which applies Sections 4 and 5, but also by way of 6(1)(b) and 6(2), what it is that needs to be pleaded and proved in claims against a magistrate in order that it cannot be defeated by an appeal to judicial immunity. So under Section 6(1)(b), it's a requirement for a plaintiff who is bringing a claim against a magistrate for an act done by him in the execution of his office to expressly allege that the act was done or omission made maliciously and without reasonable and probable cause. And
Would one way of reasoning that be a kind of pleading requirement? That rather, as you have to express, if you're going to plead fraud, you've got to give particulars. We don't say that, but if you're going to make a case, you've got to expressly allege that it was done maliciously. But it's not saying that only if it was done maliciously could you have a case.
Well, in my submission it is, and if you put together 6(1)(b) and C, you get that, because if you fail to prove that allegation mentioned in paragraph B at trial, the defendant is entitled to treble costs. So it's going beyond saying you need to plead this, it's saying you need to prove this. This is a requirement of the cause of action. Whatever the cause of action is elevated by this requirement to a higher bar, a higher threshold for this category of case. And in my submission, that delimits the scope of claims that may be brought against magistrates for acts done or omissions made in the execution of his office. It's hopeless to suggest that it's procedural only. It has to be pleaded and proved. And if you don't allege those things, your claim cannot be brought, because in those circumstances, the magistrate would have a complete defence, which is that this isn't a type of claim permitted by Section 6(1)(b), and he or she therefore has immunity. But if you do make those allegations, conversely, I say if you satisfy the requirements of section 6.1b, the section clearly anticipates that your claim can be brought in the sense that judicial immunity will not be available as a defence in such circumstances. Section 6.2 is then a carve-out from section 6.1b, because in a subset of cases that fall within both sections, in a subset of cases that fall within section 6.1a, i.e. claims against a magistrate for acts or omissions done in the execution of his office, it's not necessary to allege malice, and that is where it is a without jurisdiction case. Such claims may be maintained, that's what section 2 says, 6.2, without that allegation, meaning again that there's no immunity for section 6.2 cases. And I note that it is the same language that was used in section 45 of the 1979 Act, in which Lord Bridge interpreted as giving statutory force to outside jurisdiction claims. My fourth point, and allied to that last one, is that I say the interrelationship between section 6.2 and section 6.1 and the overall structure of this section is important. In contrast to the English Acts, going back to 1848, the Mauritian Act addresses within and without jurisdiction acts of magistrates in one section. And as I've also said, there's a relationship between 6.1 and 6.2. 6.2 is a carve-out from section 6.1b, and it relates to a subset of 6.1a cases. So the overall structure of this section in my submission is therefore that there's a broad class of case, which is defined by section 6.1a. To bring a case within that class, the Mauritian Parliament has set a high substantive bar. You need to allege malice and an absence of reasonable and probable cause per section 6.1b, and if you do, a defence of judicial immunity cannot be relied upon. But then section 6.2 says, but for a subset of cases, a narrower category, without jurisdiction cases, you can maintain the action without reaching that high bar. In my submission, if a subset of the wider class can be maintained at the lower bar, it must follow that the wider class can also be maintained if the higher bar set by section 6.1b is met.
Your statutory force point only goes to 6.2, doesn't it?
I say that's the point I was just trying to make. It reads back into section 6.1b in my submission. Because of the way that section 6.2 is a subset of section 6.1 cases. So I say that it is different to the acts of the English Acts, which have always dealt with these as entirely separate, distinct categories of action. I say when you look at section 6, that isn't what is going on here. Section 6.2 cases, which it's clear you may maintain, are a subset of section 6.1a cases.
Subset of section?
6.1a cases, to which the threshold in 6.1b does not apply. Pulling that together then, my overall submission is that section 6 of the 1957 Act in Mauritius is positively regulating the scope of judicial immunity for magistrates in Mauritius, i.e. when judicial immunity can be prayed in aid as a defence to a valid claim. And it prevents such a defence being raised both where a claim is made for a within jurisdiction act, where the requirements of section 6.1b are met, and for without jurisdiction acts under section 6.2. So I say, to use Lord Bridges' words, that it gives statutory force to both within and without jurisdiction claims.
So do you say that it's reducing the scope of an immunity that would otherwise be available at common law?
Yes.
In that case, isn't it surprising that clearer words were not used to achieve that result?
In my submission, it is very clear. It takes exactly the same language that was regarded as being decisive in Re McC in section 6.2, may maintain an action, but it deals with it cumulatively. It is, I mean, if you put them side by side with the 1979 Act, it is just a very different beast. It looks very different. And I say it is being clear that actions, the natural inference is that actions within the type described in this section can be brought. And I say that natural inference is borne out by closing analysis as well. I've given. So those are the essential reasons.
I don't know if you're going to come on to discuss the later act where the court system was reformed in Mauritius. But can I just raise something about that now? Because in one view, the act you've been taking us to is not the end of the story. If you look at the common law case law, there's a big distinction brought between superior and inferior courts, and in some cases expressed as courts of record and courts which are not record. And that was the common law background in the time of 1957. However, by the time we get to, I think it was 1971, when the Mauritius court is reformed, then we have a change in the status of the intermediate court. It's no longer an inferior court, it becomes a court of record. And if you're looking for a statutory intervention, as Lord Bridge suggested you would need, I was just wondering whether that could provide a statutory intervention to push the law on.
My Lord, yes, I see the point. Can I return to that?
Certainly.
Later in my submissions, if I may. My ultimate submission on that point is that this is the act that regulates the scope of judicial immunity for magistrates. It's clear on its terms and it hasn't been repealed. And I don't say that any later enactment has the effect of changing the clear words that are set out here. And if the intention of the legislator had been, at that juncture, to change the scope of immunity as set out in this Act, it was incumbent upon it to do it far more clearly than simply by saying, changing the status of the Mauritian court and saying, well, it's a court of record. And under the Constitution, a point I am going to come to, the only court of unlimited jurisdiction, you're quite right to make the point to me, the cases use superior courts, inferior courts, courts of record, courts of not of record differently. Under the Mauritian Constitution, the only court of unlimited jurisdiction is the Supreme Court of Mauritius.
Is there anything below the intermediate court?
Yes. Sorry, my Lord. Maybe
Is there anything below the intermediate court?
There is. There's the district court.
Right.
District
and that's
court.
Magistrates sit in that, do they?
Yes. District magistrates in the district court, magistrates in the intermediate court, judges in the Supreme Court.
Okay.
So can I just ask, on section 6.1a, do you say, and section 6.1b, do you say that creates or recognises a cause of action against the judge of the Supreme Court? Because it does say, or other court.
I do not. The reason I don't is because the way I read that is that a clerk or officer of any district or other court, which wouldn't apply to a judge. So I read it as saying, brought against a magistrate or a clerk or officer of any district or any other court. That other court could include the Supreme Court, but only for a clerk or officer.
Yes, I see. Thank you.
Is it relevant that in looking at section 6, that an action against a magistrate may not relate to something done in a judicial function, but may relate to an administrative or ministerial function? Could it be that this is really addressing that this is addressing with modifications the immunity applicable to magistrates when exercising ministerial or administrative functions?
In my submission, no. The language used in 6.1a is in the execution of his office. And I say that means his judicial capacity, effectively. So I don't...
So you say it doesn't apply to a ministerial or administrative function?
Well, obviously, that isn't this case. We're not suggesting that this is an administrative act. Administrative acts in the exercise of his office, I accept, could be within the scope of 6.1, but I don't say it's limited to that.
The reason I ask is that Lord Finlay in Everett and Griffiths, that you're going to come to, said that the protection given by the 1848 statute would not be needed if Mr. Griffiths was performing a judicial function.
Yes. Yes, he did say that. He was the only judge in Everett and Griffith to say that. All the others suggested that malice or bad faith, they put it in different terms, but an absence of good faith was a requirement for protection for someone in the position of the defendant in Everett and Griffiths. So that is what your Lord is quite right. That is what Viscount Haldane said, but the others took a different view of that point. I can come to that if needs be.
Right. Thank you.
What I wanted to do...
I'm so sorry, just on section 6.1 compared with section 6.2. I mean, section 6.1, it might be said, is predicated on some cause of action existing separately from the Act, whereas section 6.2 states positively may maintain an action. And then it goes on. So might it be said that section 6.2 reflects more closely what Lord Bridge said in Re McSee about the legislation strengthening or recognising an underlying cause of action, whereas section 6.1, read by itself, does not?
I can see the force of the point, but my answer to it, my Lord, is the one I made earlier, that this isn't, in contrast to the English Acts, dealing totally separately with within and without jurisdiction acts of magistrates. And there is an interrelationship between 6.1 and 6.2.
You say they're opposite sides of the coin. One says what you either do or don't need to aver and prove, depending on whether it's within or without jurisdiction.
Exactly, and I also say that it's relevant. I absolutely do say that. I also say that it's relevant that Section 6.2 cases are a subset of Section 6.1a cases. Because if my Lord, Lord Sales is right about that, the implication would be that you can maintain an action under 6.2, and the status of 6.1a to that action would then be rather unclear. But 6.1a is the thing that is applying all the protections set out in Section 4 and 5. So I say 6.2 cases within jurisdiction cases, without jurisdiction cases, out with jurisdiction cases, are a subset of 6.1a cases because they are still things done in the execution of his office, magistrate's office, but without jurisdiction.
Right, but I mean,
And it's
it might it not be said that you're still seeking to read back into section 6.1a the positive language in section 6.2 may maintain an action in effect only if they aver and prove that it was done maliciously and without reasonable or probable cause.
Yes,
might it be said that you're trying to read back in the positive language of section 6.2 into section 6.1b?
It might be, but I say actually that relationship is clear on its face because 6.1b says subject to subsection 2.
Right.
So I say it's not a leap for me to say that that is how the whole section as a whole should be interpreted.
Yes, I see. Thank you.
I want to briefly address, if I may, the other points taken by my learned friend in his written case on this issue. And then I need to also turn to the Constitution and the Civil Code. So I've still got a bit to get through. If we could just take up my learned friend's written case at paragraphs 28 to 29. It's in the key documents bundle, page 49. Page 49.
Yes.
At paragraph 28, he cites Anderson and Gorey for the proposition It is a matter of English common law if a judge acts within jurisdiction, no action lies acts done or words spoken by a judge, although his motive is malicious. And he then refers to a number of other cases in that paragraph, Taylor, Marinan over the page at the top of page 50, Watson, Crawford and Jenkins. Those are all cases about witness immunity. They're not about judicial immunity at all, still less the position of magistrates. And at 29, my learned friend refers to the Halsbury's extract, which was quoted by the Supreme Court, and concludes that it's unarguable to suggest that the respondent does not fall within the scope of that immunity, and that's sufficient for the board to determine the appeal and uphold the Supreme Court's reasoning. I confess I find it difficult to understand from these paragraphs quite what the respondent is saying the relevant feature of the present case is that gives the respondent judicial immunity. It seems to me there are two different ideas being floated. On the one hand, the only two sources cited in these paragraphs which are dealing with judicial immunity, namely Anderson and Gorey and Halsbury's Laws of England, both suggest that the question is whether the defendant is exercising judicial office, that's how it's put in Anderson and Gorey, or judicial functions, that's how it's put in the Halsbury's extract. And that is the Syros and Moore approach, which I've shown you. The only question is if the impugned conduct was something done in the exercise of judicial functions. But for magistrates, that's also the approach that was deprecated and overruled in Imre McC, where the House of Lords quite clearly said that's not the end of the inquiry for magistrates. You have to look at whether the act was within or without jurisdiction. And that's still true today under the Courts Act 2003. Another way of reading these paragraphs is that my learned friend is saying that the dividing line is between cases where what is impugned are words and cases where what is impugned is conduct. That seems to be the proposition he draws from Taylor and Director of the Serious Fraud Office in the middle of paragraph 28. If that is the respondent's submission, and there's no express statement that that is the reason why this claim should fail, because it's about words and not acts, but if that is the respondent's submission, I say it's also wrong. I make a brief point about it at this stage, and then I'll respond to anything further my learned friend says about it in reply. As I said at the outset, this claim is put on the basis of Article 1382 of the Civil Code. It's a claim for fault, and the way it's been pleaded is in fact as a fault grave, i.e. gross misconduct. And I don't think we need to go to it, but you see that in the plaint, the original plaint at paragraph 18, hearing bundle page 8. And what is at issue is the entire conduct of the hearing. Again, that's in the original plaint, paragraphs 11 and 14. And the allegations are that the respondent yelled, showed her muscles, sighed, used the expression chut. It goes beyond words. In my submission, the underlying action brought by my client is not to the effect that the Mauritian magistrate somehow defamed or slandered him, but rather that she conducted herself in the hearing in a way that caused him harm. So in English law terms, perhaps it's most closely analogous to a claim in negligence. It's not a perfect analogy, or possibly misfeasance in public office. But in any event, the appellant's case is that the respondent's conduct as a whole fell below the standards to be expected of a judge, and in doing so caused his harm. So whatever dividing line my learned friend is drawing at paragraphs 28 to 29 of his written case, I say it doesn't work. At 30 to 32, he describes the 1957 Act, Popper, as being purely procedural and suggests it regulates neither the cause of action, which I've accepted, but nor even the scope of the immunity, which I disagree with for the reasons I've already outlined. And he relies on a 1921 article by Sir Percy Wimfield. But in my submission, that article doesn't suggest that the acts which have regulated this historically, I think the one that would have been enforced at that time was 1848 Act, that those acts aren't regulating the scope of judicial immunity. The focus of that article is whether there's a cause of action at common law, and Sir Percy favoured the idea that there was no such cause of action. But he also makes the point that if there was a cause of action, the plaintiff would need to allege and prove under the Act that it was done maliciously and without reasonable and probable cause. So I think he is clearly accepting there that if there is a cause of action, the Act regulates the scope of the immunity that applies to it. The next point my learned friend makes at 34 to 37 of his written case is that we're wrong to say that judges of inferior courts have less protection than judges of superior courts. But again, I say, well, that's the upshot of Imre McC. You see it expressly in Law British Speech at page 747 F to G, which we looked at. And I say much of the commentary in these paragraphs and the case law here predates Imre McC, and there's a limited amount you can draw from it in light of that. And then finally, at paragraphs 38 to 40, my learned friend makes an appeal to policy considerations and suggests that even if the position were ambiguous as a matter of the common law, a clear public policy interest supports the extension of immunity to magistrates in the position of the respondent. This picks up on a point that was being put to me earlier by my lord. My answer to that is that there may be public policy reasons for extending the immunity that magistrates have, but it's a decision for the Mauritian Parliament to take. This is an area that in my submission is currently governed by the 1957 Act, and it is for Parliament to consider if it wants to amend or repeal the Act. I would also note that the policy considerations may not be the same in this jurisdiction as they are in Mauritius. A point my client has made to me, for example, is that Mauritius does not have any body equivalent to the Judicial Appointments and Conduct Ombudsman.
And you're going to come to the 1971 Act in response to the point raised by my Lord Eric, I think.
I will. I may do that if I'm... I will do
Yes.
later if I may. A point my client has made to me, for example, is that Mauritius doesn't have any body equivalent to the Judicial Appointments and Conduct Ombudsman with the power to entertain and determine complaints about the conduct, language or behaviour of judicial office holders. There's the Judicial and Legal Services Commission, which I think does have a role in disciplinary matters, but my understanding is that their focus is on disciplinary action of a gravity that would result in the termination of that judge's employment, might be removed from office. It's quite different.
Must have some procedure governing judicial complaints, don't they?
My understanding is that there isn't.
You can't go to the Chief Justice or something like that.
Oh, I might understand you can for things that are of a gravity that might remove that judge from office, but not for things that are of a lesser gravity. So, I mean, the conduct ombudsman here...
Not quite sure why that should be the case. I mean, if the Chief Justice has responsibility and oversight for the whole system, and it's being said that a judge is behaving inappropriately, even if not to the standard of removal, I can't quite see why one couldn't go to the Chief Justice and say, there is this complaint, please can you deal with it in whatever way you think appropriate?
And perhaps that could be done outside, but there's no formal mechanism like the ombudsman.
Right.
No formal...
Fairly new, relatively new here.
It is relatively new here. My point is just that one can't assume that the procedure for non-judicial resolution of these issues is the same in Mauritius as it is in this jurisdiction. And my lords will also be aware that there are other routes to obtaining compensation in this jurisdiction for example, miscarriages of justice, which don't necessarily apply in Mauritius, or, for example, under the ECHR, Article 5.5 of which provides for compensation for unlawful arrest or detention. So I say the balance that's been struck in this jurisdiction reflects a multitude of considerations. And even so, it maintains to this day a distinction between magistrates and judges of superior courts, because Section 31 of the Courts Act has done away with in-jurisdiction liability altogether, but it still preserves it, Section 32, for magistrates where acting outside of jurisdiction and in bad faith. So I say where the balance should be struck is a question for the Mauritian Parliament and not for the board.
Yes.
I'm going to move on to look at the Constitution. And again, I want to go back to how the Supreme Court approached the issue in the judgment under appeal, which is in the key documents bundle, page 71.
Page
71.
71. Thank you.
Yes.
In the middle paragraph, where it was said that the 1957 Act cannot be read in isolation, has to be construed with the principles of
I'm
the
sorry,
rule.
you're going to have to help me. We're at page 71.
Page 71 of the key documents bundle.
Ah. Thank you.
The 1957 Act, Section 6, can't be read in isolation. It should be construed with the principles of the rule of law as enshrined in the Constitution, which provides for the independence of the judiciary. And then the court cites a previous judgment of its own, the Young Sik Young case, in which it was held that judicial immunity is an important element of judicial independence. And the court in that case went on to say the provisions enshrined in Chapter 7 of our Constitution relating to the manner of appointment of judges, their tenure from office, their removal from office or for misbehaviour, and their bound and duty to do right to all manner of people without fear or favour, affection or ill will, carry with them an implied personal immunity for judges from civil suits for conduct in the exercise of their judicial functions. And in the final sentence of that paragraph, the extracted paragraph that's quoted, says this immunity is indeed the very essence of the provisions contained in Chapter 7 of our Constitution. So the reasoning of the Supreme Court in the Young Sick Young case, which is also the reasoning of the Supreme Court in this case, because it's all they rely upon, was dependent upon the terms of Chapter 7 of the Constitution. And it was adopted by the Supreme Court in this case, but without an acknowledgement of the fact that the position of magistrates is not governed by the Constitution at all. On the contrary, as is explained at paragraph 14 of the appellant's written case, neither the jurisdiction nor status of courts subordinate to the Supreme Court is defined in the Constitution.
I'm sorry, the paragraph in your case was...
Paragraph 14, my lord.
Thank you.
A
It
magistrate...
only deals with the Supreme Court, is that right?
Yes.
The Constitution?
The Constitution. Magistrates are addressed in the most oblique terms at one point in section 86 of the Constitution, which is at page 343 of the hearing, 1343 of the hearing bundle. My lords, I want to look at it briefly.
Yes.
That article gives appointment powers to the Judicial and Legal Services Commission, powers to appoint persons to hold or act in offices to which this section applies. And the offices to which that section applies are then in 86.2, those specified in the second schedule. We haven't got the second schedule in the bundle, but basically it includes magistrates. So that's the only reference to magistrates that you find in the Constitution. They're not otherwise referred to, and they're certainly not addressed in the way that the Supreme Court is
Would you
throughout Chapter
Would you
7.
agree or disagree with their reasoning in relation to the Supreme Court?
I think that reasoning is not an issue, and my client wouldn't endorse it, I don't think. But I say that's not in point in this case. The reasoning of the Supreme Court isn't being challenged, and I say that it has a clear rationale in Chapter 7 of the Constitution. My point is that that rationale does not apply to the subordinate courts. And so in my submission, it's impossible to divine from provisions of the Constitution, which simply do not address magistrates at all, an implied immunity for that rank of judicial officer. And none of the reasons...
And can you just give us the reference to the provision in the Constitution dealing with the Supreme Court, just for contrast?
It's dealt through the whole of Chapter 7, which starts on page 1339. So Section 76 creates the Supreme Court. There shall be a Supreme Court. We then have Section 77 on the appointment of judges, 78 on the tenure of officers of judges,
Yes.
79 on oaths. It goes throughout Chapter 7. So the entirety of Chapter 7 is about the Supreme Court and different aspects of its functions.
Thank you very much.
And at 82 in particular, you see the Supreme Court being given a supervisory jurisdiction over any subordinate court and an appellate jurisdiction at 82.2. It has both of those things under the Constitution.
Yes.
So I say that reasoning from the Young case, which related to immunity for judges of the Supreme Court, and was expressed by reference to Chapter 7 of the Constitution, does not apply to magistrates. And I say, nor do constitutional principles, general abstract constitutional principles of the rule of law or the separation of powers, require absolute immunity for all judges of whatever seniority and in all circumstances. I've made the point that the degree of immunity one confers on judges is a policy question, and that it is possible to devise different schemes which offer different degrees of immunity for different courts or judicial officers, but which still guarantee the rule of law. So the Supreme Court has held to my Lord Hamblin's question, the judges of the Supreme Court, the only court of unlimited jurisdiction under the Constitution, with both the supervisory and appellate function, have immunity, complete immunity. And if I'm right about what Section 6 is doing, magistrates of the 1957 Act, magistrates sitting in the lower courts will still have a large degree of immunity because they will have it for most within jurisdiction acts, i.e. those that aren't motivated by malice and done without reasonable and probable cause. And there's no real explanation given by either the Supreme Court or my learned friend as to why giving effect to the terms of Section 6 of Popper of the 1957 Act would imperil the rule of law or the separation of powers. And I note again that in this jurisdiction there remains to this day a lesser degree of protection for magistrates than for other judicial officers as a consequence of Section 32 of the Courts Act. But that's not said to imperil the rule of law in this jurisdiction. Overall, in my submission, the question when it comes to this topic is whether the implied judicial immunity for magistrates that the Supreme Court divined is required by the Constitution. And I say it's not. The Constitution doesn't address the position of magistrates at all, and so the reasoning that applies in relation to Supreme Court judges doesn't read across. And the general appeals to the rule of law do not require immunity for judges of lower courts to be granted in the face of the 1957 Act.
Yes.
My Lords, if I may take 1 minute. To my Lord Eric's point about what the 1971 Act is doing, as my Lord says, it makes clear that the intermediate court is a court of record, but the Constitution makes clear, and that's
can we just have the reference to the 1971 Act for the relevant?
I think it's at page 1357 of the hearing bundle.
Thank you.
Yeah, so I say if one contrasts what's said at 1357, which is that there shall, so section 80 of that Act, there shall be an intermediate court which shall be a court of record and which shall have criminal and civil jurisdiction. If one contrasts that with the position of the Supreme Court under the Constitution, which you can see at page 1339 of the same bundle, the hearing bundle, 76.1, there shall be a Supreme Court for Mauritius which will have unlimited jurisdiction to hear and determine every civil or criminal proceedings. I say it's still true after the 1971 Act that the subordinate courts are courts of limited jurisdiction. They might be courts of record, but they are courts of limited jurisdiction in two senses. One is that the jurisdiction they have is defined by statute. They're not courts of inherent jurisdiction. And secondly, they are subject to the supervisory jurisdiction still of the Supreme Court. And you see that in section 82.1 of the Constitution, page 1342.
But I think the point that my Lord was making was that if one operates against the backdrop of the common law, drawing a distinction between absolute immunity for judges in courts of record and qualified immunity in relation to judges of courts which are not courts of record, when in 1971 the legislature positively chooses to put the intermediate court into the first category, why does that not represent a deliberate choice of the legislature taken against the backdrop of that common law rule to put the magistrates in the intermediate court into the same position as judges with full immunity?
I'm grateful. My answer to that is that it can't do so in the face of the 1957 Act. The 1957 Act remains in force, and if the 1957 Act is clearly regulating, for the reasons I've given in my submission, the judicial immunity of magistrates, and if the intention of the legislature subsequently in 1971 was to do away with that, it needed to do so far more clearly than by saying, well, it's now a court of record. And
that would apply to outside the jurisdiction points as well.
Yes, exactly. You see, that's exactly what I was going to come on to. You see the way in which those common law causes of action have been abolished in, for example, Section 15 of the Northern Irish Act that was an issue in Remix C, or in Section 31 of the Courts Act 2003 in this jurisdiction. And I say nothing approaching that. This doesn't come close to that. And that is what will be needed to do to achieve that outcome.
Thank you.
That leads me, I think, to my final topic, which is the Code of Civil Procedure. A degree of common ground has perhaps emerged on this issue between me and my learned friend, because, as I understand his written case, he's not seeking to argue that the Code of Procedure applies cumulatively with the 1957 Act. And the relevance of this is that the courts below did consider the procedural code. I'm going to come to show you precisely how they did it. And we had thought, our submission was that what they were doing was saying that the code applied in addition to the requirements of the 1957 Act. And that another reason why this action therefore could not succeed was because the requirements of the procedural code had not been satisfied. My learned friend, in the penultimate paragraph of his written case, which is 55.3 on page 59 of the key documents bundle, suggests that the board shouldn't opine on this question, whether and to what extent the provisions of the 1957 Act and those of the procedural code may overlap or operate in parallel, because the present appeal is an inappropriate vehicle for the ventilation of that issue. And he seems to say that's because of my client's point below, that this cause of action isn't one falling within the scope of Article 505. But if you go back to the preceding two paragraphs, 55.1 and 55.2, you see the reasons my learned friend says it's not necessary to determine it. And he says that's because we're overstating what the Supreme Court in fact held. And it was no part of the reasonings at 55.2 or conclusion of the Intermediate Court at first instance that the appellant's plaint should be dismissed for failure to comply with those articles of the procedural code. And accordingly, the Supreme Court's consideration of those provisions isn't reaching that conclusion either. That's what I understand him to be saying. In other words, he's not seeking to defend the reasoning that they should be applied cumulatively, which I think means that the only question really between us is whether that is in fact what the Supreme Court held and what the courts below held. And in my submission, it's clear that they did, contrary to paragraphs 55.1 and 55.2 of my learned friend's written case. And I need to give you the history of the point briefly to make that submission good. My learned friend is right to say that Articles 505 and 510 of the procedural code were first put in issue by the respondent, by his client. You don't need to go to it, but you see that at pages 50 to 52 of the hearing bundle. And then we have to consider the role it played in the Intermediate Court's judgment. So if we can go to that, it's at page 92 of the key documents bundle.
Sorry, they were put in issue by?
Put in issue by the respondent, by my learned friend's client.
And how did that happen? Is that because the respondent said, well, what this case is really, what you're really relying on is a cause of action based on those articles?
No, that was not a submission. Perhaps we should just look at it very quickly. In the hearing bundle, pages 50 to 52.
60 to 60?
50, sorry, 50 to 52, my lord. These are submissions being made below. And it...
is this a transcript of oral?
Yes, I believe so, yes.
Yes, all right.
And on page 50, we see reference being made to the Code of Procedure Civil. It's provided for limited instances in which a judge, including a magistrate, can be sued for acts and omissions. And the procedure is very strict. And in the bottom part of that, this is a quote from another judgment. It's clear that the judicial officer cannot be sued for fault under Article 1382, but that the plaintiff has to proceed by way of the procedure of the prior party. So I think that was the submission being made by the respondent below. You need to follow the specific procedure in the Civil Code, and if you don't,
You've had it.
your claim fails. Sorry.
You've had it, I
You've
see.
had it, exactly. So then we have to consider the role it played in the intermediate court's judgment. If we could go back to that, so that's at page 92 of the key documents bundle.
Yes.
You can see it's first referred to at paragraph 23 of that judgment in the middle of the page. This comes after a discussion of Syros and Moore and the Mauritian authorities on judicial immunity. The court says at this juncture, articles 505, 510, 511 of the Code de Procedure Civile are being referred to. And it sets them out. Being referred to is maybe a bit ambiguous, but I certainly have read it as the court is referring to those provisions, not one or other of the parties. And they set out the provisions, and then at 24, they describe them as putting in place stringent procedures to be followed, which are prerequisites to the filing of a suit against a judicial officer. Thus, a failure to follow the specific procedures as laid down renders the whole action null and void. At 25, they then refer to another case, Young Sik Young. It's a different judgment to the one that was being referred to by the Supreme Court. They're referring to their own intermediate court judgment in the case, where they say the learned magistrates were faced with the issue whether those provisions, i.e. the provisions of the procedural code, are limited to acts performed by a judge in his judicial function only, and they resorted to the following extract from the Code de Procedure Civile annoté, so an annotated version of the code. I'm going to be quite candid that my French defeats me at that point, so I need to pick up the translation, which if my lords would like to follow it is on page 103 of the same bundle, the key documents bundle.
It's a bit of a red herring, that, because it doesn't matter whether they're limited to judges and their... Or is the emphasis on judge there rather than judicial function?
I think so.
Because we're talking about judicial function here.
Talking about judicial function.
So whether they apply to administrative acts or something,
doesn't
which is what all this seems to be about, is neither here nor there, is it?
Precisely. So I say from...
It's a bit of a detour.
I think that is right. So from page 103, the translation of 38 and 39 of the annotated code, which I think are equivalent to the White Book or something of that nature, commentary on each provision. The civil action remedy, either pre or partie procedure, is moreover mandatory only if the prosecuting magistrates or judicial police officers have committed the act of which they are accused in their capacity as magistrates or judicial police officers. So I think what they're saying is, in fact, it's not about administrative functions. It only really applies to judicial functions only. And then if you go back to the intermediate court's judgment, at paragraph 27, at the top of page 94, they say it's abundantly clear that the defendant was exercising her judicial function when the case was being fixed, despite uttering chut. And then at 30, we see there, at 29, they again say performing her judicial functions at the end of the paragraph. At 30, as the conclusion, ultimate conclusion on the case, the court finds that the defendant is immune from civil proceedings in the performance of her judicial function. Therefore, the plaintiff's action against the defendant is null and void.
Well, that's picking up the language of the Civil Procedure Code.
Exactly,
Nullity.
at 24. And also, yes, my lord's right, and also the language used by themselves at 24, null and void. So what I understand this passage to be saying is that the pre or partie procedure is only mandatory where the act was done in the exercise of judicial function. This was an act done in the exercise of her judicial function, and therefore the failure to follow it renders the action null and void. So I say they have applied it cumulatively. And notably, that is how the respondent appears to have interpreted it below. If I could ask you, Lordships, to go to page 89 of the hearing bundle. You can see from the header in the top right corner of page 89 that this is the respondent's skeleton argument before the Supreme Court, so on further appeal.
Sorry, we're on page 89
of the hearing
of
bundle.
the main bundle.
Yeah, the main bundle.
Paragraph?
Well, paragraph 6 and 7 I'm going to take your Lords to. I was just pointing out that in the top right-hand corner makes clear that this was the respondent's skeleton argument before the Supreme Court. And then at 6, the respondent says, The lower court, at paragraphs 23, 24 and 25, which is the paragraphs we were just looking at, additionally relied on articles 505, 510, 511 of the Code de Procedure Civile to hold that the appellant failed to follow the procedure of pria partie, rendering the civil suit of the appellant before the lower court void. And in paragraph 7, she says, she's never accepted the facts averred in the plaint in light of the wording used in the preliminary objections, but for the purposes of argument only, on the facts as averred, the appellant has failed to comply with articles 510 and 511. So I say she was saying exactly what I say the Intermediate Court found, which is that articles 505 to 510 of the Civil Code are mandatory to be followed in any case where you're suing a judicial officer, including a magistrate, and that the action was void for failure to do that. And then to complete the picture, we have to go to the Supreme Court's judgment, which is back in the key documents bundle.
Just be aware, Miss Mockford, you've got 10 minutes. Remember.
I am aware. I may go 5 minutes over, and if I do, Lord Taylor, I'm quite happy to take that off my reply time.
That's acceptable, yes.
So just back to the Supreme Court's judgment, page 67. At the start of the judgment, the court sets out the grounds for appeal. I'll ask you to read ground 3 on page 67. The ground is that the Intermediate Court wrongly took into account articles 505, 510, 511 of the Procedural Code, which had no application. And that ground is then discussed from page 76. Where you can see in the middle of the page, they say under ground 3. It's the start of the discussion of this issue. You see the submission recorded that the trial court has wrongly directed itself to those articles of the procedural...
I'm sorry, I know you're pressed for time.
No. Slow down.
It's page 76 where...
Page 76, the middle of the page,
yes.
under ground 3.
Yes.
That's where it starts. They set out the articles. They refer to another section of the annotated code. I don't think we need to spend time on that. But it's page 78, we then see the key paragraph in the middle of the page, which starts in their ruling. And I would ask your lordships to read that.
I'm so sorry, I'm not with you.
Page 78.
Of the hearing bundle or
of the key documents
of the
bundle
key documents bundle?
in the Supreme Court's judgment. Paragraph
So many
beginning.
numbers on these pages.
There are a lot of
134
there's a lot
and
of paginations
149.
done
I've got it now.
In their ruling.
Yes.
I say that's very clear. They're saying that the court below didn't rely solely on those provisions, but they did rely on them. That the code provides limited instances in which a judicial officer can be sued.
You've got to get permission of the...
including that you need
Court of
permission,
Appeal, whatever,
exactly. And then they say the provisions of the 1957 Act of Popper are to be read in conjunction with and not to the exclusion of the requirements of the code. We cannot but agree with the learned magistrates when they observe that the above provisions of the law set stringent procedures and they are prerequisites to the filing of a suit, and therefore ground 3 fails. So my submission, it is clear that the courts below found that the procedural code applied cumulatively to the requirements of the 1957 Act. And I say for that reason that paragraphs 55.1 and 55.2 of my learned friend's case are wrong. But as I've said, my learned friend seemingly isn't seeking to defend that reasoning. That's why he disavows it and says you don't need to consider it, presumably. Given that, I am somewhat in the board's hands as to how much you would like me to positively address the reasons why I say that the courts below
I think we do need to know.
Yeah.
I mean, you've shown us that both the courts below thought that this was a separate answer to the claim.
Yes.
If we're going to overrule them, I think we need to understand why.
Understandably. And the appellant submissions on that are set out at paragraph 74 to 88 of my written case. And we advanced there two alternative cases. So our primary case is that the 1957 Act excludes the application of the procedural code altogether. And in essence, that is because we say it's exhaustive of the subject matter and contains its own complete procedural code in sections 4 and 5. So I make two main points under this heading. First, Section 6, as I've shown you, of the 1957 Act, is directed specifically to civil proceedings against magistrates. And I've already made the point that it regulates both the procedural requirements which govern such challenges in Section 6.1a, which apply Sections 4 and 5, and the substantive scope of magistrates' immunity. And in so doing, my submission is that it occupies the whole field of judicial immunity for magistrates in Mauritius, establishing a comprehensive legislative scheme governing when and how such claims may be brought. And I say it cannot sensibly be applied alongside an alternative regime deriving from the Code of Civil Procedure. Second...
Sorry, why can't it sensibly be applied?
I'm going to come to that perhaps if I elaborate my second point, but I'll make that good, which is that applying the two regimes cumulatively would distort the intention of the legislature as set out in the 1957 Act. One sees that if one particularly looks at the procedural requirements, which is what the court's focus was. It's a procedural code, and it's entirely about procedural requirements. So if you look at those procedural requirements which are contained in the code and contrast them with sections 4 and 5 of the 1957 Act. So if I showed you previously, my lords, that section 4.2 of the 1957 Act imposes a requirement for 1 month's prior written notice of the action which needs to be given to the defendant. If we then pick up the procedural code, which is in the hearing bundle at page 1332. This is the English translation. The French, if your lordships wanted, is on 2 pages earlier, page 1330.
Yes.
So if one looks at Articles 507 and 508, they also purport to regulate the amount of pre-action notice that can be given in particular cases of pre-party denial of justice cases. And they say you need to give 2 requisitions. That's the French word requisition, it could be petition, a notice, effectively, to the judge via the clerk, served at intervals of at least 3 days in the case of district magistrates and commercial judges, and intervals of at least 8 days for others.
Well, this is you're complaining the judge hasn't produced a judgment or something like that.
It's a particular...
And you've got to send them 2 requests for the judgment, and then if they don't comply,
Yes.
you can do. They're shutting you out, denying you justice.
Yeah, I accept that this particular one relates to a particular class of the pre-party procedure, which is about denial of justice. I accept that. But I still say that if you were to apply it cumulatively with the requirements in sections 4 and 5 of the 1957 Act, you get to a slightly nonsensical position. We're going to have to give 3 notices at different time intervals, and it doesn't work. The same goes, and this is a broader point, it doesn't just apply to denial of justice cases, but what happens if the case is dismissed? Article 513 on this page says that if the petition is dismissed, the party should be liable to a fine of not less than 300 francs. Under the 1957 Act, as I've shown you, if a plaintiff is complaining about within jurisdiction acts and fails to prove that the act was done maliciously and without reasonable and probable cause, then under section 6.1c, the defendant is entitled to judgment with treble costs. So I say again, these are aimed at the same thing, they're regulating the same type of thing, but if applied cumulatively, one sees that they're being inappropriately layered on top of another.
I'm sorry, the provision on the amount of compensation under the code?
Under the code is 513, sorry.
513.
Yeah, on page 1332 or 1330 in the French.
But there are 2 different penalties. One is a penalty in terms of a fine of 300 francs, which presumably is pennies now, and the other one is a penalty in costs. I mean, they're 2 completely different things. You could have both.
It's true. That's true. I don't deny that, my lord. My suggestion isn't that you can't possibly apply them cumulatively literally, that it's impossible. Obviously, you could say a fine of 300 francs as well as treble costs. My submission is that doing so distorts the intention of the legislature in the later 1957 Act.
Well, unless you read the intention of the legislature in the 1957 Act as against and presupposing that the procedural code provisions also apply. And if you do that, you don't distort the intention of the legislature, do you?
Well, that's one is reading in there the idea that in addition to this complete procedural code that's set out, which specifies requirements, clear requirements for things like procedural notice, how much notice has to be given, that the legislature thought in addition to that, what we're also going to have is these further requirements that are set out in the procedural code for certain categories of cases. And my submission is there's no reason to think that is a likely thing that the legislature was intending to do. And we've referred in our written case at paragraph 82 to the decision of the board in the Raphael fishing case, where the question was how a deed that was made in accordance with a statute, an ordinance of 1874, should be construed.
Sorry.
It's in the if one wants to take it in its original, then it's in the hearing bundle, page 1290.
So, sorry, I thought you were going to your case.
Written case.
Oh, sorry.
Paragraph 82.
Yeah, sorry.
Which is
can
page 37, I think, of the key.
Do it from either, yes.
Which paragraph of your case?
82.
82.
Thank you.
My written case refers to the Raphael fishing judgment, in which the board said that the civil code may provide context but can't cut down the scope of statutory powers conferred by legislation, and that a court will fall into error if it seeks conformity with the civil code rather than for the intentions of the legislature as disclosed in the statute. And the reference there goes to 23 of Raphael fishing. It should be 24. I apologise for that. And I say, my submission, those comments are apposite, because if applied cumulatively, a plaintiff bringing a suit against a magistrate will have to meet the requirements of the 1957 Act and the Code, including obtaining prior leave, and comply with the various procedural requirements imposed on pain of nullity, and bring themselves within one of the limited grounds in Article 505.
But if one reads the provisions of the procedural code as producing an important, in effect, constitutional protection for judicial officers, and not just for them personally, but for the whole operation of the justice system, isn't it open to argument that one gets into what in our jurisdiction one would call the principle of legality, that here's a fundamental principle of the Constitution. You read the later legislation on the assumption that such a fundamental principle of the Constitution or individual right continues to apply. And I think you have said, well, you can read them cumulatively. You just say it doesn't produce a very elegant solution. But if it is a fundamental, reflecting a fundamental principle, then it may be that you should read them cumulatively.
Well, my answer to that is that you can read them cumulatively in one sense, which is that you can, I don't say it's impossible to serve 3 notices on a judge at intervals of a month and 3 days and 8 days, but I do say that that's not the balance that has been struck in the 1957 Act, and therefore just on a straightforward statutory interpretation approach, even taking into account a higher standard like the principle of legality, one wouldn't think that that is what was being intended by the legislature.
You might also rely, might do, on the requirement for permission in the civil procedural code, and that could be said to be inconsistent with the position where, at least regardless of whether you're right on your primary point, but whether you may maintain an action where it's outside the jurisdiction.
Exactly, and we make that point stated.
You wouldn't be able to definitely maintain an action if you could only do so if you had to get leave of the court.
Yes, exactly. That's a point we make at paragraph 83 of our written case. I say it's distorting the balance. The legislature has struck a careful balance in the 1957 Act as to how these proceedings should go ahead. And I say applying it cumulatively with the prior party procedure set out in the procedural code distorts that balance and isn't the right thing to do. Our alternative case on this point is that the 2 regimes are parallel regimes. In other words, a plaintiff could proceed under one or other, under the 1957 Act or under the procedural code, pria partie procedure, but isn't required to meet the requirements of both. That's for essentially the same reasons. And there are reasoning set out at paragraphs 85 to 88 of our written case. The only additional point I'd note in support of that alternative case is that there are examples of the board previously finding that Mauritian law can accommodate parallel structures arising out of its twin French and English heritage. And we referred at paragraph 87 of our written case to the authority of Gwaja and Gwaja for that proposition. And we say it supports the idea that you can have two regimes with different requirements which exist in parallel with one another, but you still don't apply them cumulatively. You don't seek to force one regime into the other regime with awkward results that would eventuate. I'm conscious of the time.
Yes.
Well, how about if your claim is under the civil code for a civil wrong, that you apply the procedural regime in the French code? If it were under the common law, you'd apply the 1957 rules.
Well, I say there's no basis for thinking that that should be the outcome that was intended when the 1957 Act, as I said earlier in section 6.1, is very broad about the actions to which it applies, any civil action. I say it's clear it encompasses causes of action under the civil code,
Okay.
as well as under the common law.
Yes. Was there anything you want to say in opening, Appeal?
My lords, and I think that concludes my submissions in opening.
Thank you very much. MacLeod.
Thank you, my lord. My lords, there's a significant amount of common ground between the parties in relation to the appeal. But the ultimate facts of this case have been slightly digressed from in relation to the cases that your lordships have heard from today. So I want to ensure that we're focused on what the actual matter that came before the Intermediate Court and the Supreme Court and is now before your lordships are. The appellant's complaint is not about an order or judgment or some other step taken by the judge in the proceedings at the Intermediate Court stage. That contrasts to every other decision that your lordships have been referred to during the course of this morning, in which a conviction or some other order or judgment of a court has been impugned in some way and sought to be the basis of a cause of action for damages. Rather, as pleaded, the case of the appellant concerns words and potentially gestures allegedly uttered or made by the judge during the course of the hearing in April 2019. And if your lordships turn up bundle, the page 6 and 7 of the hearing bundle, the complaint itself that forms the basis of the appeal is set out there. Paragraphs 11 to 14 set out the underlying words and gestures that are said to form the basis of the tort claim under Article 1382, as it's now been clarified. Although
It's the sort of thing that you could make a complaint about a judge in this country, rather than what would be outside the scope of judicial complaints, isn't it?
Precisely.
This will be within the scope of the judicial complaints procedure.
Precisely, my lord. And I have sought instructions in relation to the existence of any complaint mechanism, formal or otherwise, that might exist. My understanding is that there is a Judicial Services and Legal Commission established under the Constitution that provides for the appointment of magistrates and judges below the Supreme Court level, and that body, at least in other jurisdictions that has a Westminster model constitution, and this has been a matter that's been considered by the board on previous occasions, provides for regulations concerning misconduct of judges in relation to that, and the ability to terminate the employment or the appointment of judges at that level. I can't make submissions as to the precise position in relation to Mauritius. The point's been taken for the first time this morning. But my understanding is that if that formal mechanism did not exist by way of legislation in Mauritius, then the provisions within the Courts Act that provide for the district and intermediate courts to be subject to the supervision of the Chief Justice would at the very least provide for an informal mechanism by which a complaint as to a judge or magistrate's conduct might be able to be brought to the attention of the Chief Justice, and any consequence of that step or of that conduct could be then pursued. It's not a case in which there is no remedy whatsoever.
I did notice, in fact, as we were going through the constitutional provisions, section 86, page 1343.
I'm sorry, I missed the page reference.
1343. Section 85 establishes the Judicial and Legal Service Commission, and section 86 gives it the power to appoint persons and also to exercise disciplinary control over persons acting in such offices.
Precisely. So
what that's contemplate there is some form of disciplinary mechanism. That's
what I had in mind. What I'm not sure about, and what I have sought instructions on, is whether that power has been exercised by way of enacting subordinate legislation, which is the case in most other Westminster model constitutional systems, whereby there are proceedings or some form of procedural fairness to ensure that complaints can be raised, what misconduct
in effect,
involves,
disciplinary proceedings rather than civil claims.
Precisely, yes.
Yes.
So, as your lordships will see, paragraph 11 to 14 of the complaint, the words and gestures as alleged occurred during a hearing in open court. The matter was one which it's common ground. The intermediate court had jurisdiction to hear and determine. There was no irregularity suggested in relation to the appointment of the magistrate or her assignment to the case. It was clearly a matter that was within the jurisdiction of the judge and over which the judge had jurisdiction over the cause. So this is not a case, as Cirrus and Ree McSee were, of cases in which judges acted without or in excess of jurisdiction. It also seems now to be common ground, based on what my learned friend said this morning, that the common law was received in some form in Mauritius, at least prior to the enactment of the 1957 Act. That is, that judicial immunity is governed by English common law principles, subject to any legislative intervention that may have existed. That reflects that it's long established that what a judge says in an English setting during a hearing cannot form the basis of any personal liability. There is nothing in Section 6 of the Public Officers Protection Act, POPA, that derogates from that principle. It's a fundamental principle of the common law that a judge is immune from personal liability for what is said, and we would submit what is done during the course of an open hearing in which the court has jurisdiction in relation to the cause. And that is the principal basis upon which we submit that the appeal should be dismissed. There are three questions for the board that require determination. The first concerns what I'm going to call the source question. That is, what is the source of the principles concerning judicial immunity? The second is what I'll call the scope question. What precisely is the scope of judicial immunity as it applies to a magistrate of the intermediate court? And the third question is what I'll call the conflict question. That is, to what extent, if any, is there a conflict between the Code de Procedure Civile and the general law governing judicial immunity in Section 6 of POPA, and in what way ought that conflict, if it exists, be resolved? I'll turn to each of those in turn.
Just before you do, on your third point, are you going to be saying that the procedural code applies in addition to whatever the common law immunity position might be?
My Lord, the position as set out in my written case is that that wasn't the basis upon which the courts below determined that matter.
Right. So you'll need to help us with that at some point.
Quite. I have discerned that there may be some scepticism on the board as to whether that's the case. And if it is the case that the board considers the Intermediate Court and the Supreme Court to have determined that the provisions of Articles 505 and onwards of the Procedural Code to be applicable and be a further reason why the plaint should have been dismissed, then we would say that the two act in parallel and form a requirement in the cases to which both apply that must be met in both cases. In other words, if you're within Article 505 of the Procedural Code, then the requirements under the Procedural Code would need to be satisfied in addition to any requirements under Section 6.
All right, thank you very much.
Turning then to the source question, the appellant contends that the source of any such judicial immunity for magistrates as may exist now under Mauritian law derives its source from Section 6. That's the effect of the submission, that Section 6 now regulates the extent of judicial immunity. That contention is not borne out by the terms of the provision. Rather, the source of judicial immunity derives from one or both of the reception of English common law principles and the Constitution itself as an implied immunity to be derived from that. Let me address first Section 6 and the correct interpretation we say that ought to be adopted in relation to that, before turning to the question of the reception of common law and the constitutional point. Your Lordships have already been taken to the provisions of POPA, but perhaps if your Lordships could pull that up again. Beginning at Section 4, which is page 1588 of the hearing bundle, you'll recall that Section 4, subsection 1, imposes a 2-year limitation on actions against public officers generally in the execution of their duty. Now, that term is of some significance given that it appears later in Section 6. In the execution of an office or in the execution of their duty is a term that's wider than specifying simply within jurisdiction or within power. It is something that concerns a purported exercise of an office or a duty, as well as one which is truly an exercise of an office or a duty.
And public officer goes wider than judicial officers, isn't it?
That's right, yes. So public officer is defined in Section 2, page 1587, and means a government servant and an officer of a municipal city council, municipal town council, or district council.
Right.
Your Lordship will note, no doubt, that magistrate is not defined in the Act itself, but in the Interpretation and General Clauses Act, which I'm afraid is not in the bundle before your Lordships, but magistrate is defined to include a magistrate of the Intermediate Court as well as district magistrates.
Could that be supplied to us after
Yes.
the hearing? Thank you.
So do you accept that Section 4(1)(a) applies in this case?
Yes. Section 4.2 requires 1 month's written notice of the action. Section 4.3 provides an opportunity for a defendant to avoid the action by providing an indemnity, in fact something that has existed since at least the early 19th century as a means of avoiding such actions. Section 4.4 provides for nominal damages where a court certifies that the public officer acted upon reasonable or probable cause. And Section 5 then only applies in relation to certain types of actions, namely those arising from a seizure. It's at that point that Section 6 comes to be considered, and Section 6(1)(a) is at 1589 to 1590. Looking at the terms of the section on its own, and without any reference to the previous general principles, it's apparent that it is a procedural and machinery provision. On its terms, it applies the procedure in Section 4 and 5 and those requirements to a civil or criminal action, suit or proceeding against a magistrate. It also extends, which is important in my submission, to the position of a clerk or officer of any district or other court. In other words, individuals who would not have the benefit of judicial immunity that might otherwise be available to a magistrate. And it applies for any act done by him or any omission in the execution of his office.
So would it extend to ministerial or administrative functions?
Yes, in my submission it would, on the basis that that is an execution of the office.
And it's also reflective of the structure of the Act, which covers all public officials doing what public officials do.
Precisely.
Just saying, well, an instance of a public official is a clerk or officer doing what they do.
Precisely. A clerk or officer, it's difficult to imagine a situation in which a clerk or officer of a court would be exercising judicial functions. There may be some, such as a registrar, but many there would not be. But the intention of Section 6.1 is to apply to all aspects of the execution of those officers to which it applies. And it bears reference, to pick up a question that was put to my learned friend in relation to the position of a magistrate, that at the time that the 1957 Act was passed, and your lordships will also have seen in my written case that this particular provision has a history that goes back some 60 or so years before that. Magistrates obviously did not only have the functions that would now be associated with them, but had administrative and other functions bestowed upon them by legislation in the same way that justices of the peace did in this jurisdiction. And in those circumstances, although the office of magistrate of the intermediate court has evolved significantly and is no longer a direct comparator to a justice of the peace. Now, the reason why I say that is because it is a court, as was pointed out earlier, created in 1971 as a court of record, staffed by magistrates who are required to be legally qualified and to be admitted to the bar of one of the jurisdictions in the United Kingdom for a minimum period of 2 to 3 years. So quite different from the concept of a lay magistrate or justice of the peace as it now exists in this jurisdiction.
And that may or may not, I don't know, be a reflection of the French influence, where the word magistrate is more indicative of a judge at any level rather than our common law idea of a magistrate being a judge at the lowest level.
It may well be. My understanding of the Mauritian situation is that at the time that English administration of justice principles were introduced in the 1850s, the concept of magistrate already existed, but it was also a term that was used widely across most crown colonies as expressing the lowest form of judicial or quasi-judicial officer, and as someone who would have administrative and ministerial as well as judicial functions. So while I'd love to embrace the point in relation to Mauritius, I'm not sure that I could accurately do so. I've pointed to Section 6.1, but before turning to Section 6.1b or 6.2, can I invite your lordships to turn up page 1536 of the hearing bundle, which is section...
Before we leave Section 6.1, so are you saying that this is basically predicated on there being an existent cause of action against a magistrate?
I'm saying that there must be some form of action available under some other form of law, as in not sourced within the Act, against a magistrate or a clerk or officer of a district or other court for that section to have any function. But that does not mean that it requires or assumes or supposes that there is a cause of action available against a magistrate in relation to their judicial functions. It could simply be an assumption that it's related to administrative functions, or that it in any way regulates the scope of any immunity that that individual or that officer may have in relation to the action itself. So there must be...
So I think that's what I was trying to put to you. I think you're making the submission that you only get into Section 6.1 after one establishes that there is a relevant cause of action to which it may apply.
Yes.
Is that right?
I accept that.
And to which there's no immunity, you say?
Yes. As a matter
so far as that's different.
Yes. Sorry.
Insofar as...
the question of immunity is different from whether there's a cause of action in tort or under the code.
Yes, I'm slightly cautious in embracing that suggestion from my Lord Legate. I think it's important to bear in mind that by virtue of the hybrid nature of the system in Mauritius, in a way that would not apply in the way that the principles have been developed in this jurisdiction, that the causes of action that are available to a private party in civil litigation are sourced in the French law that was preserved from 1810 onwards. And it's for that reason, as we understand it, that the appellant has brought their action, or his action, under Article 138 8.2. And the references in the board's previous decisions concerning matters of insolvency, company law, etc., are all cases in which there has been legislation that has incorporated or enacted English principles that have then provided for, in certain cases, causes of action in those situations. But as a general rule concerning the reception of law, subject to the point that I'll come on to in a moment concerning constitutional principles, the general law as it existed prior to Mauritius being ceded to the United Kingdom was set out in the Code Napoleon as it applied within Mauritius. And as a general rule, the civil law, save where expressly altered by legislation, remains sourced within that. So in other words, one doesn't look to some identification of English common law that could in some way be received to identify a tortious cause of action.
Right.
Rather, one looks to the existing body of law as it otherwise is present. Now, that may well be enactments that have created a cause of action, or it may well be simply the civil code to identify what that cause of action is. But any question in our submission of judicial immunity arises by way of a defence to that cause of action, and due to the slightly unusual history of Mauritius as a hybrid jurisdiction, that body of principle that governs the answer to the cause of action is one that derives from English common law concerning judicial immunity.
So far as the cause of action is concerned, you said that can be derived from the civil code?
Yes.
Or
from enactments that have since been passed creating causes of action.
Thank you.
And so it's for that reason I hesitated in simply embracing what my Lord Legate.
No, I was looking to see how immunity fits into the picture on your analysis at all, but you've explained it.
And as I understand it, you say the basic cause of action is given by the code.
Yes.
But through the reception of English common law principles to some degree, English common law doesn't supply the cause of action, but it does operate as at the level of substantive law in supplying a defence by way of immunity.
Yes.
To what would otherwise be the cause of action under the civil code.
Yes, that's right.
That's the way it fits together as a matter of substantive law.
Yes.
And I think, going back to my previous question, your submission, as I'm understanding it, is that there both has to be a cause of action and no substantive law immunity available before you get to Section 6.1. Application, is that right?
I'm not sure that is right.
All right.
The only reason why I say that, I had not thought about it in quite those terms, but the reason why I say I'm not sure that's quite right is that whether or not an action is valid or possible to be brought is not something that Section 6.1a distinguishes between. In other words, one could have, as you have in this case, an invalid, or what we say is an invalid action, because it's one that's met by a full immunity in relation to the cause of action that's pleaded. But nonetheless...
you still have to bring it within 2 years.
Precisely. It is a form of action. It is a civil proceeding that has been initiated. And before you did that, so perhaps to provide an example that illustrates the point I'm seeking to advance, if one had an action like the present, in which the requirements of Section 4 and 5 had not been complied with, but it was also one in which there was a full defence by way of judicial immunity, there would be two answers to why the action couldn't proceed,
and you could
each of which would be sufficient.
And you could rely on either
Precisely.
as the defendant.
Yes.
All right. Good. Well, unless you wanted to say something urgently there, that may be a convenient moment.
I'm grateful.
Thank you very much. We'll resume at 2 o'clock, please.